Good evening. Welcome in Daily UPSC editorial audio program. Do a logic check. The Times of India. More power to fact checkers, not GOV, not government. The Economic Times. Should judges accept official post after retirement? The Hindu. Now the full editorial. Do a logic check. The Times of India. Supreme Court's right to stay the rollout of Supreme Court's fact check unit. Do a logic check. The Times of India. Supreme Court's right to stay the rollout of centers fact check unit. Too many questions, especially since polls are here. Within within a day of Government of India notifying its fact check unit under PIB, Supreme Court has stayed it rollout. Court said challenges to the rule involve serious constitutional questions. It asked Centre to wait till the case in Bombay High Court against Government of India's move to set up such a fact-check unit is concluded. Operational guidelines for the fact-check unit, enabled by amendments to rules for intermediaries, are to identify fake and false content and misinformation. The case and Jan, a two-judge bench of Bombay High Court, delivered a split verdict, necessitating a, a referee judge who is likely to hear the matter by mid April. Earlier in March, in a 2-1 order, High Court High Court gave its go-ahead to Government of India to notify the rules, which Supreme Court has now stayed. The arguments, the Petitioner Editors Guild, digital news portals, and others argued against the fact check unit on five key points. One, it violated right to freedom of speech, Article 19. Two, it promoted different rules for different platforms, since the new rules were to ensure due diligence obligations for intermediaries. That meant a print publications news shared on social media could be tagged misinformation and a pull down shot. In effect, censorship. These laws are enforced to deal with both fake and false news. For misinformation is too broad an umbrella, which without clear definition runs the risk of sweeping up dissenting views in its purview. And finally, it made Government of India final arbiter on what's fake, false, or misinformation regarding all information on Government of India. The issue, certainly, fake and false news and misinformation need state capacity to for successful counters, but to arrogate to itself sole right to identify what qualifies as misinformation or fake and false is not the way ahead to deal with this challenge. Supreme Court's stay was not on merits of the case, but Lok Sabha elections are here, so a government run fact check unit needs much more deliberation before rollout. More power to fact checkers, not government. The Economic Times. Supreme Court calls it right on Government of India conflict of interest. The right to freedom of speech and expression is constitutionally guaranteed and is the linchpin of any liberal democracy and open society, which is why even well-intentioned governments need to be reminded of this fact from time to time. On Thursday, the Supreme Court stayed Government of India's notification establishing PIB's fact-check unit, FCU, to act as a deterrent against creation and uh, dissemination of fake news or misinformation regarding Government of India's business. Being involved in a piece of misinformation makes Government of India bear a conflict of interest, thereby making it not the most neutral of umpires in disputes. The top court's stay order will be in place until the Bombay High Court decides on the challenges to information technology, intermediary guidelines, and digital media ethics code amendment rules 2023. It rules stipulate that intermediaries such as social media platforms must exert reasonable efforts to prevent users from uploading misinformation about the government that is identified as fake, false, or misleading. Failure to comply with FCU's decision on such news could result in the loss of their safe harbor status. With such a threat looming, it would be reasonable to believe that platforms would be happy to consider even unflattering information about the government that is truthful to be fake. Remember, a few months ago, the Karnataka government also proposed such an idea before protest forced it to abandon that plan. But yes, fake news is dangerous, especially with AI related tech coming into play. But a government watchdog can, as the country saw during the emergency, lead to selective targeting, censorship, and propaganda peddling. Fact checking has always been and must remain a self regulatory feature for the news industry. So, should judges accept official post after retirement? The Hindu. If a judge accepts a post retirement appointment from the government, people are bound to doubt whether their judgments were delivered for extraneous reasons. Justice Deepak Gupta is a former judge of the Supreme Court. Sanjay Hegde is a senior advocate based in Delhi. Recently, hours after resigning as a judge of the Calcutta High Court, Avijit Gangopadhyay announced that he was joining the Bharatiya Janata Party (BJP). The judge's decision to join politics and the manner in which it was taken has raised questions of judicial im- impropriety. Some people disapprove of the practice of judges holding official posts after retirement. They believe that this may impinge upon the independence of the judiciary. Others, including those in the government, have pointed out that such posts often require judicial personnel of the highest integrity, and there is no constitutional war to this effect. Should judges accept official posts after retirement? Justice Deepak Gupta and Sanjay Hegde discussed this question in a conversation moderated by Artika Bhaumik, edited excerpts. Should Justice Abhijit Gangopadhyay's decision to resign and join the BJP be considered a breach of judicial conduct by the Supreme Court? If yes, it is time for judicial reform to expressly prohibit judges of the Constitutional Court from joining official posts. Justice Deepak Gupta. Although I don't approve of Justice Abhijit Gangopadhyay's decision, I don't think he is a. I don't think there is any legal bar. However, I think the time has come for the Supreme Court to restate the values expected from judges of superior courts. The Bangalore Principle of Judicial Conduct 2002 needs to be worked out again. The manner in which the judge resigned and joined a political party doesn't speak well of judicial independence. You cannot expect any government to impose a ban or a cooling off period because they are the gainers of the existing system. Instead, the judiciary should lay down some norms on how a judge should behave after he demits office, whether on retirement or resignation. Sanjay Hegde. Justice Gupta is right that there is no constitutional bar, but expecting judges to stay away from all official posts after retirement is too much to ask for. There are certain posts for which some judges may be uniquely qualified. The real problem, as far as Justice Gangopadhyay is concerned, is that he has resigned ahead of time solely to contest the Lok Sabha elections, which is now apparent. The feeling that you get here is that you can ask a judge to resign so that he is available for elections. That too, the ask is by a ruling party at the center. This does not speak highly of judicial independence. As far as political jobs are concerned, I think the time has come for the judiciary to clearly restate its values and even take an undertaking from fresh entrants that they will not join active politics before a cooling off period of 2 or 3 years. The Law Commission has also recommended a cooling off period previously. If it were to be implemented, how long should it be for? Sanjay Hegde, a cooling off period is a healthy convention to have. It should be of at least 2 years. A judge retires from the high court at 62 years, so after 2 or 3 years they can still have an active career. Similarly, a retired Supreme Court judge will be 68-year-old after the cooling off period end. Justice Deepak Gupta, I am strongly of the view that there should not be any post-retirement appointments for judges, as I have expressed in my minority judgment in Roger Matthews versus South Indian Bank Limited 2019. For me, the bigger issue is the perception of the people. Sometimes judges may decide rightly, but the public may behave that since the judgment has come on the verge of retirement, it has been tainted by some expectations of a post-retiral benefit. Ordinary citizens are frequently up against the state, which is the largest litigant in India. If a judge accepts a post-retirement appointment from the government, they are bound to doubt whether their judgments were delivered for extraneous reasons. In Roger Matthew, I had written, one cannot expect justice from those who, on the verge of retirement, throng the corridors of power looking for post-retiral sinecures. Do you believe that judges who decide salient cases in favor of the government are more likely to secure post-retirement benefits? If so, does the remedy lie in the enactment of central legislation, since the Supreme Court has shown reluctance in the past to frame guidelines? Justice Deepak Gupta, unfortunately, the government is not going to bring any law. My view is that my competent lawyer can do the job reserved for a retired judge. They should just be men of integrity and caliber. When judges hanker for the trappings of power, it is a sad day for the judiciary. Sanjay Hegde, yes, it is often a public perception that a judge looking forward for something after retirement is more likely to benefit those who might be in a position to help him. So the power to appoint or recommend appointments should lie within the judiciary itself. It is if a reasonably fair and fair and transparent method of allotment is worked out, then one should conceivably use the services of judges in judicial functions to a greater degree. The Chief Justice of the day can be apprised of the upcoming vacancies by the government, and the next available judge can thereafter be allotted the concerned post. Increasing the age of superannuation of judges is often pitched as a solution for curbing such a practice. Some experts even say that India should follow the US precedent of granting Supreme Court justices lifetime tenures. Do you concur with these proposals? Sanjay Hegde, yes, increasing the retirement age is a possible solution. However, it might do injustice to one generation of lawyers with judicial expectations. Given the increased life expectancy and better healthcare, judges who have been performing well should possibly be allowed to continue beyond the existing retirement age. I think the US itself is in the process of reconsidering lifetime appointments. One of the greatest jobs that any presidential administration can do is to appoint younger judges so that they are able to shape the law of the nation for the next 40 years or so. A lifetime appointment for Supreme Court judges in India would possibly leave the institution burdened and negate the entry of fresh talent. Justice Deepak Gupta, I agree with Sanjay. It is a dangerous trend, and after some time, your mental and physical faculties tend to get affected. Having said that, there should be a higher retirement age, but it should not be equal for High Court and Supreme Court judges. The senior judges of the Supreme Court exercise a rather unholy hold over senior judges of the high courts only because retirement ages are different. According to the constitutional scheme, chief justice of high courts are equal to Supreme Court judges, but that is not the case in reality. Statutes regulating tribunals and commissions often provide for the chairmanship of retired judges of the higher judiciary, making them indispensable to these appointments. Is a common service or written test to secure such appointments a plausible alternative? Sanjay Hegde at that age, I don't think a written test will really work. The more you get into all this service jurisprudence, the less likely you are to have independent creatures to man judicial or quasi judicial institutions. You will only end up getting a series of judicial bureaucrats. We should ultimately learn that public belief in our profession rests largely on our ability to be of service to the nation and to harassed litigants, irrespective of which side of the bench we are at. Justice Deepak Gupta, I am strongly of the view that there should be different types of tribunal services. For instance, a tax administrative services for tax matters, and a service tribunal service and a service tribunal service for the Central Administrative Tribunal CAT, and a state administrative tribunals SAT. Young people can be taken in for these services, and then they can go up the ladder and head these institutions. Why should there be lateral appointments from the high courts or the Supreme Court to head these bodies? Justice Gupta, should post-retirement monetary perks such as pension be increased to reduce the reliance of judges on these appointments? Justice Deepak Gupta, when you join the service as a judge, you know what you are going to get after retirement. I am not sure that people want post-retirement jobs for money. They want it for the power that comes with it. If you are competent enough, you can get sufficient work as an arbitrator or a legal advisor after retirement. Thank you.